All right, good morning, everyone. We are streaming live on YouTube so we can get going. We have a status calendar this morning. The first position, Mr. Marrero, I believe has been resolved. I got the order or the motion to dismiss the charges from Ms. Hall yesterday, which said to me, Mr. Marrero did what he needed to do on the community service side.
Yes.
Great, okay. I signed it, so hopefully Mr. Marrero doesn't show up and I can't remember. I think he was for a while casting about for a lawyer because he wasn't eligible, but maybe you were
It was a sympathy case.
informally counseling him. All right. So just through you, Ms. Patel, he knows that he's all set. Okay. All right. Great. Our next two positions, I believe, are Mr. Tolles is. It's Mr. Norris. Good morning, Mr. Tolles. How are you?
Doing good. How you been?
I've been all right. You survived the pandemic? Good. It's good to see you. Are you representing Mr. Norris in both his cases? Okay, that's what we heard. Mr. Norris is here, so we can bring him out and just talk status a little bit, unless you don't want him brought out. That's really up to you. Great. Let's do that. If we could bring Mr. Norris out. And Ms. Patel, if you don't mind, just going to the gallery briefly. Ms. Hall, good morning.
Good morning, Your Honor.
You're handling both of Mr. Norris's cases?
I am.
Great. Mr. Parrish, was Mr. Harris, is he in custody or is he walking in?
I believe he's bonded out.
Okay, so he ought to be here today. We'll see what happens. All right. Good morning, Mr. Norris. I'm doing okay. How are you doing? Good. Your lawyer of, I don't know if it's lawyer of record yet, but we're going to talk about that. Mr. Tolles, who has made clear to me that he is, in fact, going to handle both your cases, is here and you're here. Ms. Hall, the prosecutor on your case, is connected remotely, so you'll see and hear her on the screen. And today I just want to get a status update, make sure Mr. Tolles has what he's entitled to, or we'll get it soon. And then I'm going to give Mr. Tolles an assignment. His predecessor on your case is Mr. Shepard, in Mr. Shepard's usual way, filed about an inch worth of pleadings. And I'm going to need to have Mr. Tolles let me know what he's adopting, what he's not. He's going to want to give both these cases his own once over to decide what are the proper motions. And he may have different motions to file. And I want to give him an opportunity to do that. So let's start first with discovery. Mr. Tolles, have you received all of the case file from Mr. Shepard yet?
Yes, I have.
Okay. And have you had a chance to look it over to see if there are things that you think you're entitled to that are missing?
Not completely. I have had an opportunity to go through a lot of paper discovery. I have gone through that on both of the cases. But as far as going through the videos and all the media, which is like 4 or 5 different things, I haven't had the time, the short time I've had a chance to go through those things. It appears to be complete.
Can you, the microphone at your table is not on. If you would tap, there's a little indentation by the red light. There we go. I think Ms. Hall is having to lean into her computer to hear you. Ms. Hall, what Mr. Toll said is that he's reviewed the paper discovery. He hasn't had the chance yet, given his recent addition to this case, to review the digital discovery, meaning the videos and whatnot. He feels like he has everything, but we'll agree in a moment on a period for him to finish that review, to let us know, is there something missing? And at the same time, to let us know which of Mr. Shepard's motions he may be adopting, and if there are any other motions that he wants to file after his review. How much time would you like, Mr. Tolles, to complete your review and let us know if there's additional discovery needed and what you're doing with motions?
Judge, how much time would the court would like to give me?
Well, I'm going to leave it to you. Your client's the one in custody. So if you need 2 weeks, 2 weeks. If you need a month, a month. But I want to make sure you've had a chance to sort of marinate in the two cases so that you develop a good position on what needs to be litigated. I don't mean trial, but if there are any pretrial things that need to be litigated and what doesn't, because then you and Ms. Hall can have the conversation about, are these resolvable short of trial, or do we need to get Mr. Norris on one of our upcoming jury trial calendars, which we're starting now?
Whenever the jury trial calendar started, Judge.
Well, they're actually underway. They aren't just this division, but actually yesterday, Judge Ellerby was supposed to start a jury trial, but had to continue it because of something that happened in that case. But we hope by late August to be back to having each division running its own calendar, so that by September, you'd be able to talk to Ms. Nelson specifically about, well, when is Judge McBurney having a McBurney calendar? Right now, the calendars are consolidated. And so I've got a few cases, and Carnesale has a few cases, and Dunaway has a few cases. And it's harder to give the lawyers a clear sense of when we might go. They're organized by age, how long a defendant's been in jail, but it's different judges. And you know quite well, one judge doesn't get to encourage another judge how to handle something. So that's what's going on.
Judge, I'm going to ask for 60 days, and here's why. In the interim, if it's 30 days, that would put me in the midst of a murder trial, which starts next week, and 2 leave of absences in July.
Okay.
So I don't want to put myself under the gun or the pressure of saying 30 days, but I know 3 of those weeks I'm going to not be able to really focus in on this case.
Sure.
I'm going to ask for 60 days. In light of the fact that they are serious cases, I want to take a comprehensive review, because I understand from Mr. Shepard, there may have been an offer on the table. That offer may expire if we go forward with motions, things of that nature. And so I wanted to give Mr. Norris the best defense I could. So I'm going to ask for 60 days.
Where is your murder trial?
It's in Coweta.
Okay, so they're back with jury trials.
They have been for a while.
Okay.
Yeah.
All right. Ms. Hall, do you have any issues with Mr. Tolles taking the next 60 days, next couple months, just to dive deep into the case and then figure out at the end of that period whether there is missing discovery or whether he's got any motions that he wants to pursue?
No, Your Honor, I don't have any issues.
Okay. Then what we'll do, Mr. Tolles, is we'll enter a new scheduling order. That'll go to you. And it will map out the timeline we just talked about. Let me make sure you are counsel of record so that when we enter the scheduling order, it goes to you rather than Mr. Shepard. Ms. Nelson says you are, and so does Odyssey. Excellent. Thank you for, oh, look at that. There's your entry of appearance. Thank you for doing that. So we'll enter a scheduling order that about 60 days out sets a motions deadline. And that'll be sort of the pivot point. If you want to adopt any of these, that's all you need to do is say, adopt Mr. Shepard's motion X. Some of these aren't particularized. So if you're adopting a motion to suppress, you'll need to particularize it, saying, well, I want to suppress the statement that I have that my client gave on date X, so that Ms. Hall would know these are the witnesses we need to have for a hearing on that. So that'll be 60 days out. Then we'd set down a date for a hearing if you have any motions that you want to pursue. And if you don't, then we'd get the case onto a trial calendar. your client still has his final plea rights. So there'd be some deadline by which he could enter a plea, but withdraw that plea if the sentence I impose is greater than what you ask for. We're typically now consolidating final plea and trial calendar. And so we'd call the trial calendar in advance, meaning several days in advance of the actual trial date. And that would be the day when your client could, if you wanted to, enter a plea, but withdraw it if the sentence was more severe than what you asked for. So there won't be a separate final plea date. It'll be the trial calendar date. Does that make sense?
Yes, it does, Judge. And I have one question. One thing I did not receive was Mr. Shepherd's actual motions. So I didn't know if you all had a copy, somebody had a copy, Ms. Hall had a copy that was downloaded. You could email it to me. I don't know if that's possible, or was it available already online, what he filed?
I assume he e-filed them. I've got a set here, but let me look. June 9th, so it's probably this June. Oh, that's the wrong year. Let's look. Yeah, they're in the docket. So you'll be able to get them that way. And some of these are actually particularized. There's a motion to suppress that talks about a witness, Jessica Smith, and a dark colored Pontiac. So you'll want to look at those. It does look like Mr. Shepherd took some time. He had his preliminary motion, which is actually about 20 motions mushed into one, about a 6-page document. It says, I basically want to suppress everything, which he files as a placeholder, but he did particularize a few. So if you get into Odyssey, you'll see them. In one of the cases, they were filed in February of this year. So you work with Ms. Hall. She may have a way to get them to you, but hopefully you can navigate Odyssey and take a look at those. And again, you don't need to reinvent the wheel. Right. If you read this particular motion filed in the case ending in 927 to suppress evidence, all you need to do is say, I adopt the motion filed on, give us the date, and then it's there. And then we'll need to have a hearing on that motion.
I'll do that.
Okay. But that deadline will be about 60 days out to adopt or file your own motions. Then we'll either have a motions hearing or a trial date. Okay. Mr. Norris, any procedural questions? We're not here to talk about the substance of your case. You do that with the man standing next to you, but you understand what we're doing next? Yes, sir. Okay. Well, you're in good hands. Mr. Tolles will work this one. If he is a little hard to reach over the next couple of weeks, you understand why. He's got a murder trial that's out of district or out of this circuit. And then he's got some other plans to deal with. But he ought to be plugging back in with you towards the end of July after he's looked over this discovery to have some serious discussions about what's the right direction for both these cases. Ms. Hall, anything else in Mr. Norris's cases?
Nothing else from the state, Your Honor.
Okay. Well, if you'll work with Mr. Tolles, he'll let you know if he feels like he's missing any discovery. If we need to change any deadlines, let Ms. Nelson know.
Sorry, man.
All right. Thanks, everyone.
Thank you, Judge. May I be excused?
Yes, sir.
Good to see you.
Same. Good luck in Coweta.
I'll need it.
Okay. So Mr. Harris is next. I'm not seeing Mr. Harris here in court. The courtroom is open. Okay, thank you. How do you tell when someone made bond? I know he got a bond.
If you click on their name in Odyssey, Judge, it should bring up a separate tab. On the jailings tab, it usually has what day they were arrested and what day they were released.
Okay.
I'm showing.
He's not in jail because the jail icon is not orange. So I got you on that.
Correct.
Oh, there's a bonds tab.
Yep.
It says no cash bond.
I'm showing he was released on October 15th of 2020.
Okay. I don't know how you find that out. Okay.
You click under parties, his name should come up, and then you click on his name. And then the new window opens up with some additional stuff. I'm still learning Odyssey myself, Judge. I'm from a Tracker County, so
Tracker.
take everything I'm saying with a grain of salt. That's what I get.
So there was a null pros order that Judge Barwick signed when it was a CP case. That indicates that, well, just know that Judge Barwick dismissed the complaint. I've never seen a null pros for a complaint, but it had to do with maybe Mr. Harris was in jail in another county when this crime occurred, but this is sort of a status crime as opposed to, it's not like it's alleged he broke into a building. Anyway, neither here nor there. We don't have Mr. Harris. Was this a notice calendar, Ms. Nelson? Okay. Ms. Patel, any insight as to where Mr. Harris might be?
Your Honor, I don't have that file. I will get it from Mr. Franklin after today. But I will say if Judge Barwick had null prossed it, he wouldn't have had an obligation to keep his address updated. And so if the case was then indicted after, there should be a grand jury warrant. And if there isn't.
There is a warrant in the system.
Okay.
Yes.
So I just ask that no bench warrant be added in addition to that, since there's already a warrant out for him.
Is the warrant in the system?
It's electronic warrant. He also has another, this is Robert Harris.
Yes, ma'am.
He has another case with Judge Cox, a P&A on July 1st, but he has another case which is open.
The case that will come to us
Yes,
Okay.
for,
same.
okay. All right. So the address in the system for him is a shelter. What I think we'll do is leave it as is and move this to judicial hold in light of the warrants that are out there. This will catch up to Mr. Harris. He has a similar case in, I don't know how you get two of these. I guess it would be 2 separate years if you register once a year in Georgia.
72 hours prior to
Okay, so the way he would have a separate, assuming it's separate, it could be that right and left hand didn't connect and he got indicted twice, maybe because of the no process of a complaint. Okay. So we'll move Mr. Harris's case to judicial hold. I assume, Ms. Patel, you'll take his other case too when Judge Cox's team bumps it to us.
Your Honor, once Miss Lacey Kyles has moved into our courtroom, which should be July 7th, both those cases will belong to her.
So when we're done with the calendar, we should talk about your promotion. Congratulations.
Thank you.
You sound excited.
More work, same pay, so,
Well,
you know.
But at least you stay in the same space.
That's right.
So Ms. Kyles has been designated as the addition to the courtroom.
Yes, Your Honor,
Okay.
that has been officially confirmed.
Has she done accountability court sometimes?
She has.
Okay,
She
so I know her. That's okay. All right. So Ms. Kyles, is that with an I or a Y? If
I
you were
believe it's a Y.
okay, But either way, your office will handle whatever number of sex offender violation cases Mr. Harris has
Correct.
accumulated. Okay. Then that's how we'll handle this one.
Thank you, Judge. I'll look into the null pros, make sure the state's not double dipping, we're not supposed to.
Well, and a complaint can be null pros and you can indict it. That wasn't my concern. I just had never, I saw this null pros order and my heart leaped that maybe this particular case is done. And if it's done, then Judge Cox keeps his. But what you may want to do is look at the two, because if they are alleging the same conduct, in other words, the failing to register in 2020, whenever then you could null pros the older one and the newer one. Do you also cover his courtroom?
I do not, but.
All the more incentive to null pros this one if they're the same.
Exactly.
So while we're just sitting here, so we don't leave, I know you've got lots of things on your plate. And we only have one more case on this morning's calendar, so we've got time. So this indictment alleges that Mr. Harris,
Our date was the 2019 date, Judge.
2019. Okay, so I bet Judge Cox is the 2020. Do you have that indictment number?
21 SC 177986.
It alleges that he failed to register in 2017. So there are two indictments, one alleging a failure to register in 2019. That's the one we've got. And then one that says he didn't register in 2017. Seems like a old decision to be spending everyone's time going forward on, but not my call.
I will get with whoever's on that one. We'll sort that out. We'll get it.
Okay, and if the answer is, look, we ought to focus on the 2019, that's fine, it'll be here. But rather than have, I'm also thinking of Mr. Harris, who's gonna have two different public defense. Is Mr. Marks someone from your office?
Yes, Richard.
Richard Marks is assigned to that, rather than having, well, we don't have a Mr. Harris right now, so no one is stuck between two places. But and Judge Cox will send us that case anyway. Ironically, even though it's the later indictment, it's the earlier conduct from 2017. All right, just let us know what the plan is, and we'll see Mr. Harris whenever he either walks into your office or gets picked up. All right,
Thank you, Judge.
thanks, everyone.
Have you excused to leave the next one?
Yes, sir.
Appreciate it.
Our last position is Brian Brown. Is Mr. Brown here? Ms. Patel, are you handling that?
Yes, Your Honor.
Because it lists actually someone who works for the DA's office as his lawyer.
Correct. He used to work for our office not too long ago.
Oh, Mr. Rhodes? Okay, I didn't know that.
About
okay.
a year and a half ago.
Okay. Now he's the top dog for non-complex. All right, let's go on the record with our final position. This is 18 SC 161997. It's State versus Brian Brown. Hello, Mr. Brown.
How you doing, Mr. McBurney?
I'm okay. How are you doing?
I'm doing well.
Good. Mr. Brown, you are here today because the Department of Community Supervision, that's probation, took out a warrant alleging that you had violated the conditions of your probation in two ways. One, you had violated your curfew and not responded to outreach from your probation officer and failed to report. And then you were supposed to be participating in the Metro Atlanta Day Reporting Center and had stopped doing that as well as of January of this year. Those are the allegations. Ms. Crawford, good morning to you.
Good morning, Judge McBurney.
How much time does Mr. Brown have on his case?
Mr. Brown has 1 year, 6 months, and 9 days remaining.
Okay. Ms. Patel, is Mr. Brown admitting to these allegations or is he contesting them?
Your Honor, he is not contesting the allegations.
Okay. Well, why don't you tell me about his situation and what you think ought to happen? Then I'll hear from Ms. Hall and we'll figure out what we're going to do.
Thank you, Judge. So, Your Honor, I believe it was in our courtroom that we placed him into MADRC. I think that would have been September of 2020.
As a result of a probation issue or the final disposition of his case?
Mr. Brown had picked up a new case. It has not been indicted yet, but I did a little homework on that case, and the charge was arson, and the conduct was not at all what was alleged in the complaint. And so we did know that in doing our research into it, that it was clear that he needed some kind of substance abuse treatment. And at the time, he didn't have enough probation left for us to put him into drug court or BHTC. And so he was in MADRC. He had been reporting between that time. I talked to his mother and she bought him a phone because I guess MADRC's daily reporting is now a Zoom call. But then he got a job with his brother doing transportation. His brother owns a truck, or is a truck driver. And so he had Mr. Brown doing a lot of warehouse work. And while Mr. Brown was working, he broke his phone. His mother, who had put out all this money to buy him the phone, was not in a position to buy him a phone again. So she, on his behalf, tried to communicate with probation and explain the situation. I understand in probation's mind, they say you need to find a way to get here, and he doesn't have transportation, which was the issue. The other issue was that while he mostly stays with his mother, he tends to float between families. And so it seems like that's an issue, because if he just stays with his mother, he has the stability to continue to report. And that was not something that he prioritized because he was working and trying to keep busy. And so when I talked to his mother, she said that the work is good because it keeps him from being on the street, and all that, because he's working for his brother, basically everybody can keep their eyes on him. But I think that he needs to understand he can't float around. I do think that right now we're sort of low on options on our end. I would prefer he stay in MADRC if they'll let him, just because ideally we've talked, Mr. Brown and I, about drug court, and he's spoken to a social worker at our office, but that's not something that we can move forward on unless that CP case gets indicted. So right now, we'd just be asking for just a revocation of 2 months and then allow Mr. Brown back into MADRC. In the meantime, I know that it's not the best option available, but I talked to his mom about, she said that he can use her phone as much as he needs to. But I do think that perhaps a requirement that he maintain his residence at his mother's and not float around between homes, which is frustrating for probation because then they can't get a hold of him.
When you say float around between homes, what are the other places Mr. Brown is staying? And I don't mean street addresses, but is it then he's at his brother's house, or he's at an uncle's house, or a girlfriend's house?
My understanding is it's his, at least when I talked to his mom, it seemed like his cousin, his brother are the two places that he was kind of in between. And so for her, she's tried her best. Of course, Mr. Brown is an adult and there's only so much that she can do. But in speaking to her, it seems like staying in one place is the best idea for him. I think that the other issue that had come up that I think was resolved at some point is that she lives in DeKalb County. So there was some confusion as to whether MADRC said, we're cool with you staying there if you video report, but if you're not going to video report, you have to come all the way down to where they are on Memorial, which when he didn't have transportation was a problem. Hopefully that won't be if he stays put at his mother's location.
Okay. Were you working, Mr. Brown, 5 days a week? Was it just the weekends? What kind of hours were you able to get with your brothers?
It was every day.
Every day? So how did you do that and MADRC? I thought that was every day also.
Well, at the time, I didn't have my phone was messed up, so I couldn't call Officer Joyce and let him know that I was working. My mom, I was in, like she said, I was in between with my brother, staying with my brother and having my cousin out with her mother-in-law. She just had a major stroke, so she's not able to move around on her own. So I was between those 3 places and not being able, when I get off work, it was 1 o'clock at night.
What kind of hours were you working?
I was working from because we would go from around the Metro Atlanta, delivering like auto mechanic parts, all kinds of parts. So it was from I would say from 9 in the morning to sometime 11 or 12 at night.
So more than 12 hours a day?
Yeah.
Okay. And you get paid for doing this?
Yeah.
And it's your brother's business?
It's a business that my brother went in with one of his friends, so it was like a joint business.
Okay, but your brother's one of the managers or owners there. Is that a job you could get back?
Well, hopefully he let me get it back if I'm doing the right thing, like she said, staying with my mother and just keep my stability with my mother, because right now she does need me and also he needs me too.
So what's happening with your cousin? How is he or she going to take care of the?
Well, I mean, my brother already gave me the weekends off, so if they need help on the weekends, I'll be able to help them on the weekends. But, only with my mom's supervision.
Okay. Ms. Patel, Mr. Brown, I assume has a bond in the CP case.
Yes.
That's not something that is also holding him in.
I did not see anything like that in the system, and I don't think that the state had moved to revoke his bond.
So we were together in September of last year, for a revocation hearing. The allegations, at least the admissions, were loitering and criminal trespass. So I don't know if that was connected with the arson, and the arson is an overstatement of what was going on with the loitering and the criminal trespass. But either way, Mr. Brown admitted to the misdemeanors. 6 months got revoked, and then he was reinstated, and that was when he was supposed to get into MADRC. How long were you in MADRC before your phone broke?
I was going daily. I was actually doing my classes online daily. And every day I would have to, every other, like Monday or Tuesday, I would have to go down and take an email.
And that would mean go all the way to probation here in Atlanta?
Yeah.
How would you get there from DeKalb?
My mom would actually drop me off down there.
Okay. And then how would you get back?
She'll give me the bus fare to go to my uncle's house. From my uncle's house, she'll pick me up once because she just retired a couple of years ago, but she just picked up a part-time job over at the post office.
Okay. So given the hours you would be working with your brother if he takes you back, how would you do MADRC?
I would have to do it in the evening. So I would have to cut down some of my hours on the job. And my brother already, they both agreed on cutting down on some of the hours. So I would be able to make it to the evening classes because they are back doing it in person in the building now. So I would have to, he already agreed to drop me off at the building and give me bus fare or come to pick me up when I get there.
Is your mom's house somewhere near a bus stop?
Yeah.
Okay. Where does your mom live?
My mom stays right off Panola Road.
Okay. So that's a main thoroughfare.
Yeah.
Panola is.
Panola
Okay.
and Compton.
Okay.
My brother, yeah.
Ms. Crawford, do you have any sense as to whether Mr. Brown could get back into MADRC?
Give me 1 second, Judge. I was going through the notes to check. Give me one more.
Okay, thank you. Ms. Hall, tell me your thoughts about what ought to happen with Mr. Brown while Ms. Crawford's looking that up.
Ultimately, Your Honor, the state wants Mr. Brown to get the help that he needs. I dealt with the case, the CP case and the revocation last year. So I do understand that it wasn't a real arson. There was no actual fire. Ms. Patel was able to get that video. That's why we were able to get the revocation complete the way we did and get him into the program. So our biggest concern is him completing the program because what we think he needs is help. I don't disagree or object to the 2 months that Ms. Patel recommended to you. Like I said, I just want to make sure he gets the help that he needs. So our position is if he can get back into MADRC, then we'll be okay with him completing that program. But if he can't, I think we will have to come up with a better solution to get him the help that he needs other than just putting him in jail.
Mr. Brown, thank you, Ms. Hall. Mr. Brown, remind me, what is the drug or substance that you struggle with the most, such that we were talking about drug court and then we got you to MADRC?
Okay.
Powder or crack?
Both forms.
Okay. I'm going to ask some questions that I'm not assuming anything. I just want to understand the situation. Does your mom use any of that stuff?
No.
Does your brother use any of that stuff? So it's not your family members that pull you back in. It would be friends you've got or places you go to hang out. And that's where you, okay. But being at your mom's house is a safe place for you as opposed to a place that would, okay.
Judge, I'm getting the officer on the telephone, so give me just another moment.
No problem. Take your time. Thank you. So the petition said you violated your curfew, but how did curfew work if you were working those kinds of hours?
Because I didn't let them know I was working at the time. So I waited it. So they would come in and see me. Officer Joyce, they would come in early in the morning and see me.
Yeah.
And from there, I can go out and work until the evening.
Okay. Sounds like it was too bad you broke your phone. How did you break your phone?
Funny part about it, coming off the truck.
It just fell out of your pocket?
No, I was actually unloading it. I was not unloading some washing machines because we do a lot of warehouse work.
Mhm.
So we was unloading washing machines that day. And me and my brother was tussling with one of those big old tumblers. You know, the big tumblers that's in the wash house. And it broke in between one of those tumblers falling over.
Got it.
And you know how sensitive those LGs are.
Okay, Judge McBurney, I sent you a message. Check it and then you get it with me.
Got it. Thank you.
You're welcome.
So, Mr. Brown, I think it's going to make more sense to try to have the structure for you driven by family, and by the work you're doing, based on where your mom's house is and where MADRC is. I don't think it makes a lot of sense for you to keep doing MADRC. Well, first of all, it makes a ton of sense for you to do MADRC because you need it. But that said, and acknowledging that you would benefit from what they've got to offer, I have two observations. One, some of it you've begun to internalize because I didn't say but 2 or 3 words and you said people, place, thing. I mean, you know, you may not practice it, but you know some of the thinking that you need to adopt to stay out of harm's way. And more time at MADRC would help reinforce that. But based on some of the feedback I'm getting, I think that it sets up an unrealistic challenge for you to get from your mom's to MADRC and juggle work. And it's going to get folks at MADRC frustrated because maybe you're not showing up as often as you should. And then we have to have this conversation all over again. So what I think I'm going to do is get a curfew in place, a requirement that you live at your mom's house, and we'll get all that information in a minute. That'll probably mean that you report to probation in DeKalb rather than in Fulton, because that's where your mom lives. The reason why you were still plugging in Fulton was because MADRC was here. I don't know that it will be easier to get to the DeKalb office from your mom's house than it was to get to Fulton's, but that's how probation works. You are supervised based on where you live. And it sounds like from what you're telling me and Ms. Patel is telling me, you living with your mom is the smartest and safest way for you to be. That means you can't stay at your cousin's house as much as you may want to be helping out. When probation comes knocking, if you're not at your mom's house, I'll expect them to swear out a warrant and just get you locked up again, which doesn't help anyone. So first, I do find that you violated the terms and conditions of your probation by effectively walking away from MADRC. And I understand there were some technical reasons behind it because the phone broke, but in the end, it's on you. It's not, no one blames the giant washing machine. And you weren't complying with the terms of your curfew, but we'll get that real clear. As a result of all that, I'm going to revoke 30 days. I'll give you credit for the time you've been in. And I think you got scooped up more than 30 days ago. It looks like maybe May 20th, but we'll figure out what day you got arrested. I'll reinstate the balance, but I'm going to add some pretty clear conditions. Number one is you need to reside at your mother's house. What is that address?
5822 Calico Court. My
What's-
daughter-
5822
Calico,
Calico.
yes.
Calico Court.
Lithonia, Georgia. 30358.
Look at that. That's what's on the petition. Good. So you'll need to reside there. That means that that's where you spend every night. We'll also put in a curfew. Unless you are able to document that your brother routinely needs you to be working beyond a certain time. You said, what time does your workday usually start?
From probably about 7 o'clock to, he actually starts a little earlier than that sometime, but I would say about 6 or 7.
All right, well, I'm gonna have your curfew be 9 PM to 7 AM. And if you need to modify that, you just talk with your probation officer and he or she can adjust it. But you need to document why. If your brother writes a note saying, I need to pick Brian Brown up at 6:30 every morning, let's make your curfew end at 6 AM. I'm not really worried where you're gonna be at 6 AM. You're either asleep or you're working. It's more, where are you at night? So for now, the curfew is 9 PM to 7 AM. That means that if probation is looking for you at 10 PM, any night of the week, you're at 5822 Calico Court. You're going to have 2 random drug screens every month. So you're going to get a call from probation saying, come on down, and you need to come on down and take that drug screen. And you're going to need to maintain employment. So hopefully your brother will take you back. But if he doesn't, the good news for you is everyone and everything is hiring right now. So you ought to be able to find a job. I know you've got a criminal history, but that is not holding folks back right now because they need folks working everywhere. So you're gonna need to maintain employment, stay with your mom, you've got the curfew. If you are not working at least 30 hours a week, for any week you're not working 30 hours a week, you need to do 10 hours of community service. So that's an incentive to stay busy. And we'll get you structure one way or the other. Ms. Hall, do you have any other conditions you want to have added to Mr. Brown's situation?
No, Your Honor, I think you covered them all.
Okay, so I'm removing the condition that he complete MADRC, but maintaining or adding these other provisions. Ms. Crawford, I guess you need to does Mr. Brown need reporting instructions, or he's already on probation, or how does this work now that he's going to officially be a DeKalb supervisee?
I will give him a date to report along with the address for DeKalb County.
Okay.
You all can write it, someone can write it down there. The address is 2910 Miller Road, Miller Road, Suite 150. I'll give him the reporting date of July 13th at 9 AM.
All right, so, yes, ma'am, keep going.
I was just gonna say, if he has any questions, I'll give him my number to contact me.
Okay.
And that number is 470-303-6860.
And so we're clear, Mr. Brown, Ms. Crawford can answer questions you've got. She's not your probation officer, so she's not the one who'll be supervising you. But if between when you get out and July 13th, you forget where you were supposed to go, or something comes up, or your mom moves to Gwinnett County, you should give her a call. Do you have any questions about any of that?
No, sir.
So where are you going to be living?
At my mom's house.
All right, and hopefully your brother will be good enough to take you back as an employee. Ms. Patel, anything else in Mr. Brown's case?
No, Your Honor.
All right, Ms. Crawford, do you need anything else?
No, Judge, that's it for me.
Okay, well, thank you, everyone. Appreciate it. I think we're done with the calendar.
Thank you, Judge.
Thank you.
Do we have a different calendar, or we have to have a different Zoom this afternoon? It's the same one? So Department of Corrections is just going to plug in? Okay, great. So Ms. Patel, how is it going to work in terms of Mr. Franklin's caseload and whatnot? He told me when he broke this news that he's going to hold on to a handful, but fewer than 5 cases because of long-term relationships with clients and the age of the case. And we're going to try one of them this month, but fate conspired against us. So he'll be back to take care of a few of those, but the rest go to you, or you and Ms. Kyles are going to flip coins, or what's going to happen?
Ms. Kyles will still keep the same indictment numbers, which was 0 to 4, but I will take any of the murders, rape, aggravated sodomy, and aggravated child molestation. So essentially anything with the mandatory minimum of 25 and above, that'll be mine. And so I've spoken to Mr. Franklin. I think he was keeping Goolsby and Bonaventure Flores, and then maybe Daryl Lowe, but my understanding is the county's starting a backlog project. And if that actually starts, Daryl Lowe would probably go there.
Yeah, I wouldn't bank on that, but TBD.
Right.
So you think it would be 2, maybe 3 that he's keeping?
Right, of the murders. I know that he had toyed with perhaps keeping one of his sex crime cases where he knew the client. I know that there's one coming up, John Connor. So I grabbed that file yesterday. So hopefully I'll get to speed on that.
Is that the guy who's in Douglas County?
Right.
Yeah. So definitely talk with Mr. Franklin, talk with Ms. McCauley, who has been plugging in with Douglas. And I don't know if you remember, but the plan was that for almost identical conduct, he'd go to trial in Douglas, and maybe that would resolve things. If it was a disaster for the state, then maybe the state makes a decision here. If it's a disaster for Mr. Connor, then we could probably work this one out. But then it didn't go to trial. Right.
And it sounds like Ms. McCauley stated, at least in the motion that I read, that it's being held off indefinitely. Okay. I don't know why, but.
Okay. What will likely happen before any backlog system begins is that we'll be back to having our own calendars. And those will get published. And then after they're published, we'll get a chance to sit down, just the lawyers, to talk about, look, you have 5 serious cases on here. Right. What are 2 that you could be ready on this? Ideally, you don't go back to back, but if Ms. Kyles isn't going to have initially her share of those kinds of cases, you might be going back to back. Right. But we'll work with you and obviously the prosecutors to try to structure that so that we're using the first few cycles of our trial calendars in a meaningful way for those cases where it's guy's been in jail for 3 years, right, et cetera. But we'll also do bond cases. In fact, you saw the email. We can add bond cases now to these consolidated calendars. And if they're old enough, they'll probably go out because we keep running through the calendars. Everyone pleads or the state dismisses or there's an indefinite continuance. So Ms. Nelson and I will be looking at our oldest bond cases, and then you'll get one of those happy emails like, why can't we add this to one of the upcoming consolidated trial calendars? If only to get movement on the case. The state looks at the file and says, you know what, actually it's a misdemeanor. Great, resolved. So we'll sort that out. I assume the plan is after maybe you've done a few of the serious cases with Ms. Kyles as a second chair, then she'd begin to get into that rotation, or it's you?
Our office doesn't really have a guidelines on that. I mean, I started taking them after 6 months when I was moved into complex, but some people wait 2 years. I think that Ms. Kyles fortunately is confident in her skill set. So as soon as she feels ready, I think that I'm more than happy to trust her with some of that stuff.
All right. And as far as you can see into the crystal ball, you're not going anywhere.
As far as I see it, I don't think that they're going to try to move me. It seemed like they were trying for a while to break both of us up because they just didn't like that we were both in the same courtroom when we could be helping younger attorneys.
Sure.
But hopefully we don't have a mass exodus anytime soon.
Right. No, I think part of what you call backlog is meant to bring more personnel to both your office and the DA's office to help work through. It's not necessarily old cases. It may be if there is a spike in indictments, because that's been forecast, that you get the new attorneys on those new burglaries and drug cases, et cetera, because there'll be new attorneys, but they can manage those, and that doesn't pull you and Ms. Kyles away from these cases that have been around longer and aren't going anywhere absent a trial. But we're working through what that design will look like. I don't think it will be, but it's not my decision, the classic Judge Baxter gets the 100 oldest cases and there's just this queue of people, because you have to stay with your kid. It doesn't make sense to, but it can be a different prosecutor. They're fungible, but not so with the defense attorneys. And that hobbles all the other judges. If I'm saying, great, let's go to trial on Sherry Grant, which is one that you will get from Mr. Franklin. And you say, I'd love to, Judge, but I'm in front of Judge Baxter on a backlog case. Right. And then judges get angry and some of them don't manage that well. So we'll see. But in the meantime, you're here. I'm excited about that. And you've got this whole new portfolio of cases.
Right. I went from one murder to a lot more. So. But I'm going to try to get up to speed. And I think that Mr. Franklin is still trying to figure out the final, what cases he'll be able to.
Sure. Well, I think it is great if he'll hold on to a few of them. He told me definitely Bonaventura and Goolsby. Right. And there were a couple that were sort of on the threshold. And it was maybe I keep them because we can work them out. Kind of thing, but still he's in a better position to help the client manage that process than you, only because he's been working with that person a little bit longer. Exactly.
And I know that Mr. Lowe has been through the ringer. So I know that that's a case that he would feel bad coming off of at this point.
Okay.
Okay.
Well, good.
What's Ms. Kyle's first name?
Laci, Laci.
Okay.
You may recognize her when you see I know you don't come in for drug court, but she covered drug court. There was this, I'm blanking on, we had someone who did drug court for a long time and then she left. She was going to be like the public defender in Clayton, but that didn't work out. She went somewhere else.
Oh, yeah, I know who you're talking about.
Johnson, Adeline?
No, it was someone different. But then Ms. Kyles filled in until Ms. Primovic sort of became the full-time. Right. But when Ms. Primovic gets pulled, as she often does, somewhere else, Ms. Kyles pops up like, hey, I'm here to do drug court. And it's always been, to your point about being pretty confident about how to navigate things. It's been real smooth, because sometimes when you get a stand-in, the person says, we're just going to have to continue that because I don't know anything about the case. Well, the whole point is for you to get up to speed. Speaking
of which, I will be standing in tomorrow, but hopefully I think we have a calendar tomorrow.
Tomorrow's drug court.
Right.
Or you're going to do drug court.
I will be doing that.
Excellent.
I guess they're having something at the Supreme Court that Ms. Primovic is checking out.
I want to be there. It's the My Journey Matters graduation, and Justice LaGrua is hosting it. Carnesale took over for it, but there are going to be a lot of muckety mucks, and LaGrua has said, hey, you need to be there. I messed with drug court 2 weeks ago. I can't mess with it again. So Wednesdays are bad luck. It'll be low impact for you. I don't know if we have any terminations, but basically you hold the hand of the person who's going to be terminated. And then it's this calendar, which is our revocation calendar, and it's only 2 defendants. It's 3 cases, 2 defendants. And you'll just want to connect with Ms. Collier, who handles it for the state.
Ms. Sellers is not.
No longer. It's
Gotcha.
Ms. Collier. Mr. Rhodes, your former colleague, is now Ms. Collier for non-complex, and Ms. Collier is Ms. Sellers for the accountability courts. And she will have very thoroughly worked up these 3 cases, again, 2 defendants. And they're on here not because they just got kicked out of drug court, but they were in drug court and then they were terminated and still had a lot of probation left. Those come back to whatever judge had them in drug court. We don't return folks to the judge who sent someone to drug court.
Gotcha.
So we'll just be working through if it's going to be a revocation or if you need more time or what.
Okay. Well, I will talk to Ms. Primovic.
Great.
Thank you, Judge.
You bet. So we are back. We've got a hearing at 1:30. It's criminal, it's virtual in the sense that the defendant's in state custody. So he'll be dialing in, hopefully, well, I don't know if the lawyers will come in. I'll be back out here just before 1:30 to patch in with Department of Corrections, and there may be lawyers in here. And that's it. All right, thanks.
Take the image down.
Excellent. I'll be out of here in a second, but we're good. Appreciate it. All right, I will see you guys around 1:30. Thanks.
Oh, so it was good. They just, you know, you have your book stuff, man. I would eat it. I probably eat it like later.
Ms. Nelson. Ms. Nelson, are you there?
Hey, Judge,
How are you?
how you doing?
All right,
Excuse me for the disturbance.
not a problem.
Uh, can you get this equipment up? Or no?
That's fine.
It's fine.
Yeah, if it's too loud, I'll let you know. We're about to start a Zoom.
You about to start
A Zoom thing, but I don't get the sense anyone's coming in. We'll see. I think it may all be online.
we can do it later, whatever you want.
Oh, is it only one?
It's 1:15.
Hold on one sec. I'm 15 minutes early, so how long do they need?
Where's the, let's speak to cultural. We're all over at about 15 minutes. Can you do 15 minutes? You want to do it now? Get 15 minutes? Just okay, this the whole 15 minutes.
It's all good. I'll be back. I came out early. I don't know why I thought it was at 1:15. I'll be back. What time did I stop?
He's not in yet.
That's pretty good. Come on. Hey, how you doing? Yeah, think about it. When you get there, think about saying something over there.
This shouldn't be long. This shouldn't be long. Oh. Good lunch. Yeah, we went to the salad place. You know, I don't know the name of it. It's, over there off of Memorial. Really? It's nothing but salads.
That's good.
You
Like
go
a salad bar?
You just tell them what you want.
I like those.
It was good.
They have seating and everything,
You have to wear your mask till you eat,
right?
you know,
Yeah.
but it was good. We really wanted to go to, another place, but I was not thinking of it.
I know what you mean.
Homegrown.
Oh, wow.
Have you been there?
Yeah.
We want to go there, but I don't know, there, something's gonna.
Madam Court Reporter,
Yes.
your mic is on. I just wanted to let you know. Not that I don't mind listening to you. You have really nice voice, but I just wanted to know that wanted you to know in case you didn't want your conversation to be on YouTube.
That's okay. I'm asleep.
Hello.
This right here.
I guess that was nice of you to say. Thank you, Mr.
See.
Oh, okay, all right, thanks. All right.
Hello.
Oh, hello.
How do things look?
I took some pictures.
Okay. Jonathan had some folks here doing something with equipment in the little space, that exit area.
Yeah, they have, it smells good.
Oh,
so
good.
That was a plus.
Oh my
but they have
gosh,
to
look at
take
the
some
wall.
panels off the walls.
Okay.
But the stuff is still going, it's still in there drying. They took
Wow.
all the baseboards off,
Look at that.
but.
I think they'd learn with these toilets.
This one?
Yeah, see the room, the door with a little tornado on it? That goes into a jury room that we share with Judge Leffridge's team.
Oh, so.
And there's bathroom in there.
Judge McBurney kept her clothing.
Yes, and there's still stuff from their toys and things in there. She didn't quite clean it out, shockingly.
There's more.
Exactly. But this is the same thing that happened in Judge Russell's jury room. Remember, we had water in 1D.
Yeah.
It came all the way down from 8.
They probably should replace
All the toilets, yes. We're just waiting one by one for them to pop. Yikes. Okay. Good afternoon. This is Judge McBurney. Before we get on the record, let me make sure we can hear everyone. We've got Ms. Sleeper representing the state. Is that correct?
Yes, Your Honor.
Great. I can hear you. Can you hear me?
Yes, Your Honor.
All right. And we've got Mr. Francis. Good afternoon, Mr. Francis.
Hey, good afternoon, Judge. Can you hear me?
I can. Good to see you. And most importantly, we've got Mr. Strickland. Mr. Strickland, you able to hear me?
Yes, sir.
Great, there he is. All right, well, let's get on the record then. The court reporter is here in courtroom 8D. We've got Mr. Strickland at Jenkins Correctional Center. Mr. Francis is appearing from his secret location, and Ms. Sleeper is appearing remotely as well. This is case 10 SC 96080. And I'm going to provide a little bit of procedural background, and then we'll let Mr. Strickland take it from there because he has filed a motion that he wants to pursue. In May of 2013, Mr. Strickland entered a guilty plea under North Carolina versus Alford to voluntary manslaughter and 2 firearms offenses. It was a negotiated plea. I've reviewed the transcript. He was at that time represented by Mr. Francis. He, Mr. Strickland, had actually had several different attorneys. At one point, Thomas Robinson. Mr. Robinson sought to withdraw after he and Mr. Strickland had a disagreement at an immunity hearing. Mr. Oden, who is with the Conflict Defender's Office, took over the case from Mr. Robinson and was representing Mr. Strickland up until what I'll call the eve of trial. I don't know that it was the day of, but close in time to Mr. Strickland's trial, Mr. Francis, who was Mr. Oden's supervisor and the director of the Metro Conflict Defender's Office at that time, stepped in and became Mr. Strickland's lead counsel. We had jurors ready to go on Monday, May 6, 2013, when Mr. Dutcher, the prosecutor, and Mr. Francis, Mr. Strickland's attorney, informed me that they had reached a negotiated resolution. We had a lengthy plea hearing at which time Mr. Strickland explained that he understood what the terms of the plea offer were, that he accepted them, and that he was satisfied with the work that Mr. Francis had done. I know Mr. Strickland had been frustrated with some of the other lawyers who had worked with him. I followed the joint recommendation and sentenced Mr. Strickland to 30 years to serve. Fast forward a little less than a year, Mr. Strickland filed a motion to modify his sentence that has been denied. Fast forward even more to August of 2020, and Mr. Strickland filed a handwritten motion for an out-of-time appeal relying on the Georgia Supreme Court case of Collier, Collier, which is at 307 Georgia 363. And he supplemented or replaced, and Mr. Strickland can tell us which one it is, the handwritten motion for an out-of-time appeal with a typewritten one that was filed just less than a month ago, May 24th of this year. It incorporates large portions of the August 4th, 2020 motion. Pursuant to Collier, as Mr. Strickland pointed out, he is entitled to an evidentiary hearing at which he can bring forth whatever evidence he wants to, suggesting that he was denied the opportunity to appeal whatever an appeal would have looked like from his guilty plea, appeal either his plea or his sentence or both by some action or inaction of Mr. Francis. We're not going to talk about the merits of whatever the appeal might have been, but rather why was it that Mr. Strickland, through counsel or on his own, did not timely file an appeal? I think that's the right confines of a Collier hearing. But I think procedurally, that's where we are. Let me start, Ms. Sleeper, by asking you if you have anything you want to add procedurally before I turn to Mr. Strickland.
Your Honor was very thorough. That's everything I have on my list as well.
Okay, great. Mr. Strickland, tell me if you agree that with my description of why we're here today and what we're going to work on.
Yes, up until that part about after Mr. Robinson, I had Mr. Hobbs get back on my case for a day and drop my immunity motion. And
Okay.
he back off my case. You know, he was a conflict of interest at that. He told me before I hired Mr. Robinson, he could no longer represent me. And he was a conflict of interest. Then he got back on my case right after I fired Mr. Robinson, and he dropped my immunity motion against my consent.
Okay, that all may be true. That doesn't change what we're doing today. But I do recall that Mr. Hobbs had a conflict because of either some witness the state was going to call, or maybe even the gentleman who was shot and killed in this case. Either way, it was not Mr. Hobbs who was your lawyer in the months leading up to your trial, and it certainly was not Mr. Hobbs who represented you at the time you entered your guilty plea. Do you agree with that?
I agree.
Great. Okay. So we're here today on your request. So if there is evidence that you want to admit, either things you want to testify to under oath, or if you want to ask Mr. Francis any questions, we can do that. But it's your job to establish whatever record you want to try to make, that there was something that Mr. Francis failed to do, or he did do, that caused you to not be able to appeal your guilty plea or your sentence. So I am ready for you to let me know what you want to do.
Yes, I would like to question Mr. Francis.
Okay. You understand, we'll get Mr. Francis under oath in just a minute. If you move forward with asking Mr. Francis questions, you will be authorizing him to reveal potentially privileged information. In other words, you're going to be asking him about conversations the two of you had or failed to have. And by doing that, that will allow Ms. Sleeper, as well as myself, if I have any questions, to ask Mr. Francis about things you may have told him or he may have told you in the context of your lawyer-client relationship. Not 3 months earlier when you may have said, hey, this happened or that, but all about the plea and things he may have told you or in your mind neglected to tell you. You understand that that will be fair game for Ms. Sleeper and myself as well.
Yes, sir.
Okay. Well, with that acknowledgement, what I'll do is ask the deputy to come on up to one of these screens so that Mr. Francis can see and hear him. We'll have the deputy swear in Mr. Francis, and we'll go from there.
Easy, Mr. President.
You know what will work best? If you go up to the podium, that's the magic microphone that covers everything.
Mr. President, can you hear me?
Yes, sir.
All right, you raise your right hand. You swear and affirm testimony to give the court the truth, the whole truth, nothing but the truth, so.
I do.
Well, I say the truth, records.
Dennis Francis.
Anytime you can't hear him, then let me know.
Mr. Strickland, when you're ready.
All right. Mr. Francis, you and I have not talked or met prior to today, have we?
No, sir.
Well, just so we're clear, you haven't talked or met recently, but Mr. Francis, you're not saying you've never met Mr. Strickland before?
Correct. We have met.
Okay. That was just a while ago. It's been a minute, as people say.
Right.
Yes.
Okay.
Do you recall about when it was that you've been appointed to my case?
I can't. No, I don't. I don't remember when it was. It was about the time that the judge recited, though.
It was like a week before trial, before I was dressed out. It was that Wednesday before I was dressed out that Monday. You had previously represented me during the pending charges, correct?
I don't recall, but I don't dispute it if it's on the record.
Well, Mr. Strickland sort of gave a narrative there, but at the end, when he was looking at the questions he's prepared, I understood him to be asking you, Mr. Francis, and correct me if I'm wrong about this, Mr. Strickland. Mr. Strickland was asking you, Mr. Francis, if you represented Mr. Strickland in connection with these charges.
Yes.
What were the specifics of your employer for my pending matter?
Could you say that one more time? The specifics of what?
Of your employer for my pending matter.
I'm not sure if I understand what you're asking me.
I'm asking, when you represented me, what was you doing? You know, your job.
Well, my job. Yes, sir. My job was to represent you in your case, which could have meant going to trial, or it also meant exploring an opportunities to resolve it.
We never talked about my case. So you are aware that I had undergone several exchanges with counsel during the pending 3 years to these charges.
Yeah, I'm aware that
McBurney had this.
Hold on 1 second. You're having trouble hearing Mr. Strickland? Yeah. Okay. So Mr. Strickland, it would help if when you're free to refer to the tablet that you've got, that's fine. But when you're talking, if you could look up, the court reporter is having trouble hearing you when you're looking down and talking. Okay?
Yes, sir.
Thank you. But you're doing a great job.
Did you ever file any appeal once I had entered into the plea and been sentenced?
No, sir.
Okay. Wouldn't you agree that no one had informed me about any ability or the right to a direct appeal? Instead, I've only been told about the habeas corpus ability that gave me up to 4 years to appeal, correct?
That was a compound statement. The first part, I cannot agree that you weren't informed about your rights, all of your rights, and you know, I can't remember every specific conversation that you and I had, but it's as a matter of course, I pretty much go over what your rights are. Direct appeal, that's another issue, because you don't have a direct appeal from your plea. So I wouldn't have used the phrase direct appeal. So if to the extent that you're asking me if I ever said that you could directly appeal it, I would have never said that, because you don't have that right. I would have said you had a right to file a motion to withdraw your plea and have a hearing as long as you filed it within the term of court in which you entered your plea.
Would you not agree that my case history since the time clearly established I wanted to appeal, hadn't I?
Objection, Your Honor. I've given him a lot of leeway since he's a pro se defendant, but he's asking a lot of leading questions and a lot of testifying that if we could eliminate a little bit of that.
I appreciate your concern. I'm going to let Mr. Strickland ask the way he's going. I think that he's just trying to establish some baseline information from Mr. Francis, and I think we'll have a more productive hearing if I let Mr. Strickland proceed in this way. That said, you should feel free if there's a question that is just so overly suggestive, let me know, Ms. Leeper, but I am not finding that Mr. Francis's will is being overborne by the way in which the questions are structured.
I understand, Your Honor. Thank you.
Sure.
You
should repeat the question so we're all in the same place, please, Mr. Strickland.
Yes, sir. Would you not agree that my case history since the time clearly established I wanted to appeal had not?
I'm not exactly sure I understand what you're asking me.
That I wanted to appeal my sentence? Okay.
I don't know. I have no knowledge of that because we had no communication I don't recall any communication afterwards.
And in fact, given the rule to the merger on the multiple possessions of firearm charges under Gaston versus State, case number A12A0962, decided August 7, 2012, reference Nazarian versus State 2013. When you agree that a merger issue certainly gives rise to file an appeal?
I mean, a merger issue can give rise to further post-conviction procedures, but I'm not in a position to give you an opinion about, about whether you and I didn't have that conversation. I don't believe about a merger issue on your gun charges.
We had an issue because the possession of found by a convicted felon and possession of found during commission of a crime is a lesser included offense. And I asked you specifically about taking the lesser one off.
So, Mr. Strickland, what you need to, right now, what you're doing is telling Mr. Francis something. What you need to do is ask him questions. I'll give you a chance to let yourself be put under oath, and then you're free to tell me what you want to tell me about your discussions with Mr. Francis. But when you're asking Mr. Francis questions, that's what you need to do, is ask him questions rather than say, well, let me tell you, we did this and we did that. Okay?
Yes, sir. Yes, sir.
Thank you.
An appeal that would have prevailed under Regents versus State 2015. Your Honor, that's all the questions indeed to ask former plea counsel to be granted the out-of-town motion. But I have more on the errors, and while I am in no way waiving my rights or desire to do so, it is, however, imperative that I be furnished a copy of the transcript records I requested so that I'm able to properly address these concerned issues. What have you with my former counsel such record would erect?
Got it. I'm going to see if Ms. Sleeper has any questions for Mr. Francis, because he's on the stand right now. It's a virtual stand, but we'll see if Ms. Sleeper has any questions. I may have a couple questions, and then I'll ask you, Mr. Strickland, if you have any other evidence that you want to get in the record. Ms. Sleeper, do you have questions for Mr. Francis?
Yes, Your Honor. Mr. Francis, thank you for your time today.
Thank you.
And I just wanted to clarify for the record, Mr. Francis, did you represent Mr. Strickland in the matter of 10 SC 96080?
Yes.
And do you know what type of charges Mr. Strickland was facing?
It was a murder charge.
Okay. And what was the potential sentence that Mr. Strickland was facing?
A mandatory life sentence.
Okay. And that was life without possibility of parole, right? Correct?
Well, this was a 10 case.
So maximum.
Right, maximum life, yeah.
Without possibility of parole, correct?
Well, this was 2010. It was a 2010 case, so SB 13, but I can't, I'd have to, yeah, but currently life without possibility of parole.
So if
the record is, just to weigh in, there's a fairly lengthy discussion about possible penalties Mr. Strickland might have faced if he were found guilty at trial, and whether it was life without parole because of the amendment to the statute that Mr. Francis was referring to, or because of his prior convictions. That was all covered in the colloquy of which Mr. Strickland and Mr. Francis were a part. So the fact that you don't recall every minute detail is fine. That the record's not murky on that one. It was a murder case, and Mr. Strickland was facing a pretty serious outcome if the trial didn't go well. There was a justification defense that was out there as well.
So I guess my next question was, if the transcript says that you had advised him of life without possibility of parole as maximum sentence, that would be correct.
Yes.
Okay. And did you negotiate a plea deal with the state?
Yes.
And what was the offer by the state?
My understanding is it was a plea to voluntary, which was 20 years to serve, and then followed by the a plea on the gun charge, possession of firearm during the commission of a felony, which was consecutive 5.
And another consecutive 5 for the possession of firearm during the commission of felony, correct?
Yes.
Okay. So overall, it was 30 years sentence that he was looking at, correct?
If the record says that, I believe so.
And did Mr. Strickland take the plea in that matter?
Yes.
Okay. And before taking his plea, did you inform the defendant of his right to trial if he doesn't want to take the plea?
Yes.
And did you inform him of his rights to appeals after the plea?
Yes. If right to file a withdrawal of the plea first.
Yes, that was my question. Yes.
Right.
And did he understand your explanations?
Yes.
Okay. And did he still want to take the plea?
Yes.
Okay. And did he take the plea voluntarily, knowingly, and intelligently?
Yes.
And did he get the result as negotiated by the state?
That's correct. Yes.
And after the plea, do you remember if he expressed to you that he wanted to withdraw his guilty plea?
I don't recall that.
Okay. Or did he express, or do you have memory of him expressing that he wanted you to appeal his guilty plea?
I don't recall. I don't have a recollection that he wanted me to do that.
And were you aware of any non-frivolous or legitimate grounds to appeal the guilty plea on behalf of defendant?
No, I was not.
Okay. And at any point in time after the plea, do you remember him contacting you and asking you to appeal his guilty plea?
I don't recall.
Okay. And that's all the question I have.
Mr. Francis, I appreciate that this is all a ways back and you've had a few clients since then. But as you reflect on the work you did for Mr. Strickland to include securing a meaningful reduction in his potential exposure in this case by way of the negotiated plea, is there anything that comes to mind that would have prompted you to ignore a request from Mr. Strickland, had he made one, either to file a motion to withdraw his plea or to file whatever a direct appeal of a plea would look like?
No, normally in situations like that, if I'm contacted after we negotiate a plea, which we thought in good faith was a good plea, we wouldn't just leave someone out there. We would notify them, send them a letter and explain what their rights are, and then have additional counsel appointed if we thought it wasn't in good faith that we file it. So we wouldn't have left him there by himself. He would have been instructed as to what to do and how to do it.
Okay. Got it. Thank you so much.
I'm certain that, I've worked out cases with Pat Dutcher before, and it's not a fly-by-night exercise. You go over a number of details, and I've been in front of Judge McBurney before. We go over the details. So I am certain that we went over the details and went over his rights and gave him every opportunity to ask questions and think about it. And so I'm confident that we did that. And
one other question in that area, there is in the docket, so in the record, a guilty plea form that is used in my division that lists a whole bunch of rights that a defendant has and other aspects of a plea that it satisfied with counsel, the plea is knowing and voluntary, the details of the plea, in other words, how many years the defendant expects he'll be getting, et cetera. That's in the record. It was referenced in the plea colloquy, and it has your signature, which you verified in the record, and Mr. Strickland's that he verified. Is that document that has, Mr. Strickland didn't actually put his initials next to each thing. He wrote the word yes next to each thing, but that suffices. Is that a document that you would have gone over with Mr. Strickland before getting up in court to go forward with the plea?
Right. Well, that was the requirement of the plea. That was a precursor to the plea. So I don't even recall that document, but some judges have it, some judges don't have it. And if it's in the record, and we went through the document probably minutes before we came out to take the plea, and he initialed his section or signed his section, and I signed my section. So I would have gone over each and every line with the client and made sure. And part of that includes references to post-conviction rights.
Okay. Thank you.
Okay. Thank you, Judge.
Mr. Strickland, is Mr. Francis free to go?
Yes.
Okay. Thank you, Mr. Francis.
Judge.
Mr. Strickland, is there any other evidence you want to present? I mentioned that if there's testimony you want to give, you're free to do that. Of course, you'll then be subject to cross-examination by Ms. Sleeper if she has any questions for you.
Well, Your Honor, I ask that you give me a little more time, at least 30 more days. I need my transcripts that I've been asking for, that I failed to get. I've been asking for them for the longest, and I need all of the transcripts to proceed.
So you're not entitled to a transcript at this point. If I grant your motion for an out-of-time appeal, then you'd be entitled to a transcript. It's only one transcript. It's not plural. It's the transcript of the plea hearing. So if I grant your motion for an out-of-time appeal, then you would get that transcript, and you'd be able to move forward from there. But for today and the hearing on your motion for an out-of-time appeal, you've got what you've got, I've got what I've got, and I just need to know if there is any evidence that you want to admit through your own testimony, or if you're going to rely on the answers that we now have in the record from Mr. Francis, which is fine. There's nothing wrong with that. I just don't want to shortchange you if there was something more you wanted to get in the record.
For this, I ask Your Honor to rule on my record request and reschedule or continue this hearing 30 days at the most to prepare.
Okay. Ms. Sleeper, is there any evidence that you wanted to get into the record as I work through Mr. Strickland's motion?
No, Your Honor. I would just object to the continuance.
Okay. I'm not going to continue the matter. I will include in my order language about the request for the transcript, but I've already explained my view, which is informed by reviewing the case law that's developed since this Collier opinion that Mr. Strickland has properly relied upon to get us to where we are today. But as I understand it, Mr. Strickland, if we're not going to continue this, if we're going to wrap up today, then you've presented what you want to present, and Ms. Sleeper has presented what she wants to present. Is there anything more, Mr. Strickland, that you want to share with me at this time?
That's all I have for plea counsel, Your Honor. There's nothing else I want to share with you.
Okay, so I'm curious, you've got a tablet there. Is that something that inmates can use at Jenkins to help them with their legal work?
Yes, sir.
Is that how you were able, I mentioned when we got started, your first motion, I'll just hold it up to the screen, you don't have to read it, that's the handwritten one. And then we fast forward a few months and there's this fancy typewritten one. Is that also because you're able to use things like that tablet?
Yes, sir.
All right, that's very impressive. I'm glad that the department is making those kinds of tools available to the inmates. All right, well then the record is closed. I will get an order out that will get mailed to you, Mr. Strickland. It'll get e-filed. It'll go into your docket as well, and Ms. Sleeper will get a copy of it. And if I grant your motion, Mr. Strickland, then we'll work through getting you the transcript, those kinds of things. If I deny the motion, then you will, in your usual industrious way, decide if there's something else you need to file, and we'll go from there.
Your Honor,
Yes, ma'am.
is it okay if I actually add an argument for the record since we didn't file any brief to respond to this defendant's motion?
If there's something you think I need to know, I'm happy to hear it now.
Well, that's a very difficult question you're asking. I mean, you have all the evidence, and Judge McBurney, you know the law, so I don't think I have to teach you the law. I have full confidence you know the law, and also how you will review all the record. I just, in my practice, I always put in some sort of argument in the record. But if you don't think that's necessary, I will not.
I think I'm good, but I don't mean to preclude you. If there's something brief in a summary format that you want to share, that's great.
Sure, Your Honor. So if I could quickly summarize the state's position on this, as the court have correctly said, this is motion for out of time appeal. And defendant's claim is that his plea counsel failed to timely file a withdrawal motion or notice of appeal to the court's conviction that was entered on May 6, 2013. And he's basically arguing that his counsel was deficient and that caused him to lose his appellate rights. And in these circumstances, the court reviews it under Strickland versus Washington standard, which there are two components. As to first component of Strickland standard, the defendant must show that his appeal right was lost as a consequence of his counsel's deficient performance. In this case, it would be that his counsel did not consult him about his right to appeal. And of course, Mr. Francis testified today that he did, in fact, consult with Mr. Strickland regarding appellate rights and motion to withdraw guilty plea, and followed all proper measures in informing the defendant of his appellate rights following the plea. And this was done before the defendant went to take the plea. As for the second prong of Strickland standard, is a defendant is required to demonstrate that there is a reasonable probability that but for counsel's deficient performance, he would have timely appealed. But once again, that's not the case. Defendant did not show that today. And the counsel has testified that he informed the defendant on appellate right, motion to withdraw guilty plea, and proper ways of appealing the matter after the plea if he needed to. And if I could quickly go through the facts, Mr. Francis also testified that he does not remember defendant asking for an appeal after his guilty plea. Rather, defendant wanted to take this plea since it was a great plea deal considering he was looking at life without parole. And this is in the record, plea transcript record. And moreover, defendant did get benefit of the plea bargain offered by the state. He did not express any dissatisfaction with the plea agreement, nor there's evidence of such. And he did not reserve any ground for an appeal. And there's no evidence that defendant ever wavered in his desire to plead guilty. And to the contrary, actually, the record shows that it was a defendant who sought to end the judicial proceeding by pleading guilty in order to avoid the possibility of the harsher sentence, which would have been life without possibility of parole. And nothing in the record before the court supports a finding that a rational convicted defendant would have sought an appeal under these circumstances. Likewise, the record shows that defendant has not expressed any interest in withdrawing his guilty plea until last year, which is more than 7 years after his guilty plea. And also during the plea, defendant expressed only satisfaction with his counsel's performance. And based on the record and the testimony from today, it is clear that plea counsel did not have any reason to think that a rational defendant would have wanted to appeal. nor did he actually express such to Mr. Francis. For those reasons, state respectfully requests that this court deny defendant's motion. Thank you.
Thank you, Ms. Sleeper. Mr. Strickland, this is your motion, so I want to make sure you get the last word if there's anything more you want to add. I appreciate how prepared you were and the thoroughness of your pleadings. Anything you want to add after you've heard from Ms. Sleeper?
Yes, sir. I put in a motion within the year, within the following year, for motion to modify my sentence. And I also took the plea because I just met Mr. Francis the Wednesday before I was dressed out Monday to go to trial. So we never talked about my case. So having Mr. Francis represent me, period, I was not comfortable with that.
Okay. Mr. Francis, you had Mr. Oden leading up to just before Mr. Francis appeared. Is that right?
Yes, sir. We talked about my case one time, but we never really talked about my case. I wrote the state bar on him because he told me the laws bend around certain situations. And Mr. Francis took over. But me and Mr. Francis never discussed my case before I was dressed out to go to trial.
Got it. And I think you put that in your motion as well. Well, I want to thank the good folks at Jenkins for getting Mr. Strickland on the screen and getting him his device. And I will take his motion and the state's oral response to it under advisement and get an order out soon. Thank you, everyone.